Salutations to all our future judges. In this video, we are going to see the test series with respect to sections 11 to 16 under the Code of Civil Procedure 1908. As you have all asked for by way of voting, this would be in the form of a test series wherein a question would be shown on the screen and certain amount of time would be given to you for answering those questions. Within that time, you need to answer that question and you need to make a scoreboard for yourself and identify how much you have scored in this particular test series. This would help you in your judicial exam, and further, this would enable you to think in a better and a prospective way. I also thank Mr. Balaji, who is a volunteer who has helped me in getting certain questions, which could be presented to you. If you would appreciate his efforts, please do press the thumbs up button and show how much you like this way of teaching. And in addition to this, in comment section, if you want to write something about Mr. Balaji, that would be most appreciated. Sections 11 to 16 of the Civil Procedure Code 1908. The first question is, to fall under the category of res judicata, A suit should be between the same parties in a former suit. B, the former suit should have been tried and finally decided by a competent court. C, issue in the present suit should also be the same as the former suit. D, all of the above. The answer is all of the above. Now let us move to the next question. The term former suit means suit which was filed in a prior date. B, suit which was filed in the beginning. C, suit which has been decided prior to a suit in question. D, date of filing or judgment or immaterial. The answer is suit which has been decided prior to a suit in question. Let us move to the next question now. Which explanation under section 11 of Civil Procedure Code 1908 states that the competence of a court shall be determined irrespective of any provisions as to a right of appeal from the decision of such court? The answer is explanation 2. Now let us move to the fourth question. Matter directly and substantially in issue in the former suit should be A. Admitted directly, B. Admitted impliedly, C. Denied expressly, D. All of the above. The answer is all of the above. Let us move to the next question. Whether a matter which was taken as a ground of defense or attack in the former suit will be taken as a matter directly and substantially in issue in the later suit. The answer is yes, it will be. Let us move to the next question. Question number 6. If a court does not expressly grant a relief claimed in the plaint by way of a decree, then the relief A is deemed to be refused, B is deemed to be granted, C varies from case to case, D none of the above. The answer is deemed to be refused. Let us move to the seventh question. Question number 7. A, B, C and D are the only owners of flats in an apartment. A files a case for pathway to the apartment and succeeds in the case. If again B files a second case for the same pathway, the second suit will be A. Res judicata, B. Res sub judice, C. Res gestae, D. Res ipsa loquitur. The answer is res judicata. Let us move to the next question, question number 8. Whether section 11 of Civil Procedure Code of 1908 is applicable to a proceeding for the execution of a decree. A. Only in certain situations, B. In all situations, C. Depends on the discretion of the judge, D. None of the above. The answer is in all situations, B. Let us move to question number 9. Under which circumstances res judicata will be applicable? A. When the court trying the subsequent later suit is competent. B. When the court trying the subsequent bar later suit is competent or incompetent. C. When the court trying the subsequent bar later suit is in a foreign jurisdiction. D. None of the above. The answer is B. When the court trying the subsequent later suit is competent or incompetent. Let us move to question number 10. The word rules referred to in section 12 of the Civil Procedure Code 1908 includes A. Forms contained in the first schedule. B. Rules made under section 122. C. Rules made under section 125. D. All the above. The answer is all the above. Section 12 specifically mentions this particular fact. Let us move to next question, question number 11. Which of the following is incorrect? So please read the question properly. It says which of the following is incorrect, not which is correct. Option A. Foreign judgment is conclusive when it is pronounced by a court of competent jurisdiction. This is option A. Option B. Foreign judgment is conclusive when it is based on merits. C. Foreign judgment is conclusive when it is opposed to natural justice. D. Foreign judgment is conclusive when it is based on correct view of international law. The answer is option C. Foreign judgment is conclusive when it is opposed to natural justice. Let us move to question number 12. Mr. A files a case against his brother in a court in United States of America by producing a forged document and obtains an order in his favor. He produces it in an Indian court for execution. In such a scenario, A. Court cannot accept the foreign judgment since it is obtained by fraud. B. Court can accept the foreign judgment since no fraud was committed in Indian court. C. It does not fall under section 13 of the Civil Procedure Code 1908. D. None of the above. The answer is court cannot accept the foreign judgment since it is obtained by fraud. Let us move to question number 13. Foreign court gave foreign judgment on a claim violating the provisions of the Indian Contract Act 1872. Whether that foreign judgment is conclusive in India. A. Yes, since foreign countries decide cases based on the law of their countries. B. No, since foreign judgments cannot be conclusive if they violate Indian law. C. There is no difference between foreign judgment and Indian judgment when it comes to claims. D. There are no conditions for a foreign judgment to be conclusive. The answer is option B. No, since foreign judgments cannot be conclusive if they violate Indian law. Question number 14. A foreign judgment is conclusive A. When it is not pronounced by a court of incompetent jurisdiction. B. When the merits of the case are overlooked. C. When the country passing the judgment failed to recognize Indian law. Option D. When the judgment is obtained by fraud. The answer is when it is not pronounced by a court of incompetent jurisdiction. Question number 15. Which provision under Civil Procedure Code 1908 speaks about presumption as to foreign judgments? A. Section 14, B. Section 21, C. Section 22, D. Section 28. The answer is Section 14. Question number 16. To determine whether foreign judgment was issued by a competent foreign court. A. Certified copy of the foreign judgment should be produced. B. Photocopy of the foreign judgment is sufficient. C. Email copy of the foreign judgment would suffice. D. Text of the foreign judgment should be transferred to the court email address. The answer is certified copy of the foreign judgment should be produced. Question number 17. The foreign judgment produced before a court is deemed to be genuine only when it is furnished in the form of a hard copy with attestation, B. Document appearing to be a certified copy of judgment, C. E-copy of judgment pronounced by a court of competent jurisdiction, D. None of the above. The answer is document appearing to be a certified copy of judgment. Question number 18. Section 15 of the Civil Procedure Code states that A. Every suit shall be instituted in the court of the lowest grade competent to try it. B. Every suit shall be instituted in the court nearest to the plaintiff. C. Every suit shall be instituted in the court nearest to the defendant. D. Every suit shall be instituted where the cause of action arose. The answer is every suit shall be instituted in the court of the lowest grade competent to try it. Section 15 speaks about this. And now let us move to the next question. Question number 19. Section 16 of the Civil Procedure Code deals with jurisdiction for filing civil suits with respect to A. Recovery of immobile property with or without rent or profits, B. For the partition of immobile property, C. For foreclosure, sale or redemption in the case of a mortgage of or charge upon immobile property, D. All of the above. The answer is all the above. Let us move to question number 20. Mr. Ram is planning to file a suit seeking relief by way of personal obedience from the defendant in connection with a wrong committed to immobile property. In this situation, where Mr. Ram should file his case? A. Court within the local limits of whose jurisdiction the property is situated. B. Court within the local limits of whose jurisdiction the defendant actually and voluntarily resides. C. Court within the local limits of whose jurisdiction the defendant carries on business or personally works for gain. D. Any one of the above. The answer is any one of the above. Question number 21. The compensation for wrong to an immovable property can be obtained through institution of suit. 1. In the jurisdictional court within which the property is situated. 2. In the jurisdictional court within which the defendant's residence is situated. 3. In the court incompetent to try such suit. 4. In the court whose jurisdiction covers the workplace of defendant. Options: A. All the above. B. 2 and 3 only. C. 1, 2 and 4. D. 1 only. The answer is 1, 2 and 4. Let us move to the next question. Question number 22. The word property used in section 16 includes only A. Only immovable property situated in India. B. Only movable property situated in India. C. Both movable and immovable property situated in India. D. Both movable and immovable property situated outside India. The answer is both movable and immovable property situated in India. Question number 23. The term property as interpreted in the explanation of section 16 of Civil Procedure Code 1908 means a property situated A. At any part of the world. B. In India, excluding the state of Nagaland. C. Anywhere in India, excluding Union territories. D. In any state or Union territories within the territory of India. The answer is in any state or union territories within the territory of India. 24th question. This is the last question. For recovery of movable property under attachment, a suit should be filed. A. Within the local limits of whose jurisdiction the property is situated. B. Within the local limits of the residence of the owner of the movable property. C. At any court which the owner of the property deems appropriate. D. None of the above. The answer is within the local limits of whose jurisdiction the property is situated. If you like the video, please do press the thumbs up button and leave your comments in the comment section. And do subscribe the channel and also share the channel with your friends. Let us join hands together and contribute for a learned society. Thank you.